Good morning, everybody. Thanks for taking a few minutes out of your morning this morning to join in the call. We have a guest this morning, and I also want to respect his time. So we will start with his presentation, and then we will end with the things that we usually talk about. Our guest this morning is an attorney. His name is Richard Heller, and we asked that he would join in one of our calls. I know that we talked about this topic a while ago, and we just wanted to get more information and another perspective. And the topic that we're going to hear about from Richard this morning is estate and probate planning, specifically as it pertains to what we do and what our customers need to be aware of. So yeah, that's what we're going to talk about. Do you require screen sharing capabilities, or would you like that?
Please.
Okay, absolutely. I will give that to you right now. You're good to go. So whenever you're ready, sir, take it away.
All right, just give me a second to get myself together here. All right. Can everyone see my screen?
Yes, we can.
Okay. Hopefully it's not the pictures of my wife and home and so on. Okay. Well, first of all, let me just start by thanking Ben Laube and Jadel, for inviting me to chat with you. It's a subject that really has a little bit of meaning because it actually does become an issue in my practice. So our topic, which is really how probate and estate planning affect a realtor's job, has meaning to me, and it should have meaning to you also. As you can see, there's a lot of issues that we perhaps share, that we have in common. And a lot of these issues may very well affect the sale of your property. And so, which of these issues may affect your sale? I don't know. Well, maybe none of them, but I'll lay odds with you. You're in business long enough, you're going to see some of them. Now, I had shown this presentation to my wife, and she said, "Oh my God, Richard, it's so dry." And well, yeah, that's my life, I suppose. So I said, all right, well, at least I'll then start out with a joke, get things going, at least a little bit on that positive side. So, bear with me. So an old man is on his deathbed, and he wanted badly to take some of his money with him. He calls his priest, his doctor, and his real estate agent to his bedside. "Here's $30,000 cash to be held by each of you. I trust you will put it in my coffin when I die so I can take all my money with me," he said. Well, at the funeral, each man put an envelope in the coffin. Riding away in the limousine, though, the priest suddenly broke down in tears and confessed, "I only put $20,000 in the envelope because I needed $10,000 for a new baptistry." Well, since we're confiding in each other, the doctor said, "I only put $10,000 in the envelope because we needed a new machine in the hospital, which cost $20,000. Well, the real estate agent was absolutely aghast and held his head up high and said, "I'm ashamed of both of you. I want it known that when I put my envelope in that coffin, it held my personal check for the full $30,000. Well, that's my bump for the day. Now, as realtors, you're in the business of buying and selling real estate. Your clients may be young, old, they speak English or a foreign language, they're sophisticated or uneducated, rich, poor. However, they've chosen to come to you because you have the resources, the education, and the knowledge to move their transaction forward. As you know, there's a great deal more than simply writing a form contract. The longer you're in the business, the more you'll find that you have unique circumstances. Sometimes you may be the first person to identify an issue of concern that could, if unresolved, terminate the contract and possibly your eventual commission. Now, the best realtors I know, and basically are going to have the education, the knowledge, and the constant background to continue to basically make sure that all these issues are addressed. And a lot of these come up in estate planning and probate. So first, let me just tell you a little bit about my background. I have a Juris Doctorate from the University of Miami. My undergraduate was the UM, and my undergraduate degree was in finance and real estate. So I actually, my focus was in the area of real estate. I'm a member of the Florida Bar, same year I graduated, and a member of the Real Property, Probate, and Estate Planning section of the Bar, as well as the Elder Law Division. And of course, I have all the backgrounds and the ratings and everything else that you would hope to see. So I see a lot of these issues that come up. So for me, spotting issues, pitfalls is very important. And I think realtors can do that. And I'm not saying that you need to be an attorney, but I think just spotting the issue early is going to be so helpful to you. So when you speak to a potential seller of property, you're going to review, and you go to their house, you take a look around, and do not look at the dirty carpet. Listen to the squeaky floors. Smell bad odors from the poorly located trash cans. Don't you see the water spots on the ceiling? And if it's an older home, you're looking for possible electrical wiring that may be an issue. Of course you are, because you're good at what you do, and you're looking for the best deal for your clients. And you're looking to protect them too from a bad deal. A review of a person's home should also really include a little bit of investigation into the title ownership. Is this the original owner or subsequent owner of the property? Was the property conveyed at the time by quitclaim deed? Always worry about quitclaim deeds, especially if they were done by individuals. I constantly, on almost a weekly basis, run into bad quitclaim deeds. Did the current owner get the property in a divorce? Is the former spouse still on the deed? Did one of the owners pass away? If an owner passed away, was the property titled individual, tenants in common, joint tenants, tenants by the entirety's life estate, enhanced life estate? Are you sure the property was not owned by a trust? If so, was it a revocable trust? Was it an irrevocable trust? Is your seller the beneficiary of the owner's estate? If so, has the interest been probated? Has there been a determination of homestead? I'm really going to spend a little bit of time on homestead because that's so important. Very often, you look to the property appraiser's office to see who owns the title. I know I go there very often to take a quick look, and I'm sure you do too. Well, be concerned when it says estate. That means something hasn't happened, and you need to be a little concerned. Also, don't assume that the person who's named at the property appraiser's office actually has marketable title, because they often don't. If the first thought that went through your head as I'm saying this is, I just leave that up to the title company, that's not my concern. Honestly, I wouldn't want you to be my realtor, would be my thought. Without understanding these issues, you may be setting up the potential seller and yourself for a significant loss of time, money, aggravation, and a poor working relationship. Instead, I would want my realtor to be the most highly educated and knowledgeable realtor in the industry. Now, estate planning, just so you understand, I want to explain a little bit about estate planning. I'm not going to spend too much time on that itself, but when people have their estate planning in place, they feel good. And the purpose behind it is to make a transition from their assets so that upon death, they easily or more easily transfer to someone else who would normally be a beneficiary. The goal, of course, is to not have as much, not only issues with the transfer, but also to make life easier for the people they leave behind. So estate planning, it's the process basically of determining assets and liabilities, evaluating what you would like to happen to your property now and in the future, and determining which tools would best meet your needs to make the transfer. Working with your estate planning professionals to implement a plan. Some of the tools that we use for estate planning: wills, advanced directives, durable powers of attorney, which are also often very important in your industry because people often do sell property using a durable power of attorney, and they need to be properly drafted for good title. Trusts, gifts, jointly held property, life estate, life insurance. Those are some of the tools. With every probate or estate planning client that I see, I always inquire into their assets and how they are titled. And I let them understand how these assets will be distributed upon their death. So what I'd like to do is discuss in a nutshell some of the major issues of concern that I share with realtors. In order to do that, I really need to define a few terms, okay? Now I have somebody waiting to enter a waiting room. Do I need to let them in?
Just did it.
You did it?
I did, yep.
Okay, just want to make sure. Okay. So when it comes to probate, understand, is basically just a legal process where a will is determined to be valid or invalid if there is a will, and the assets and liabilities of the decedent are administered. The advantages are that you have a court determination of assets and liabilities, which for your practice is wonderful because you now have somebody that actually can sell the property, has legal authority. Homestead issues can be resolved. That's also extremely important to deal with the homestead. The disadvantages is it's time consuming, and that's a problem I'm going to discuss with you because as realtors, you need to understand that you, especially in today's market, you have the ability to sell property almost immediately. You just need to make sure that they have the financing and you're pretty much good to go. However, the court may not be good to go. The probate may take longer than you anticipate. And so I'm going to be telling you about a few timeframes that you should be aware of coming up. And one key thing to understand, probate, having a will doesn't avoid probate. It just simply instructs how the probate should move forward. And the problem is that it doesn't automatically transfer real estate assets. And a lot of people that I see think, well, I have a will. The will says the property goes to me. I don't have any brothers. I don't have any sisters. I don't have this. I don't have that. It should be very simple, right? Wrong. If that property is not in your name, it still needs to go through a legal process. Trusts. Well, a trust is a different animal, so to speak. It's a fiduciary relationship that's established by a grantor or settler who then gives another party that we call a trustee the right to hold property, to invest property, to sell it, do what they want for the benefit of another party that we call a beneficiary. And there's a lot of different types of trusts, and some of them may very well affect you. Revocable trusts come up quite often in real estate transactions, sometimes irrevocable trusts, real estate trusts. And what you need to basically just make sure that the trust has that authority to sell the property at that time. But that also is a method basically to hold and transfer property that's more commonly used. And the nice benefit to the trust is that it does bypass, in most cases, not every case, the probate process. Sometimes even if your homestead property, the primary residence, is in a trust, it still needs to be determined to be homestead by a probate judge. Confuses the heck out of people because they thought they put it into the trust to totally avoid probate, and yet they still need to do it. The will itself is simply a declaration of a person's wishes when a person has a will. And it's just how they want to dispose of property upon or after death. And again, a will doesn't avoid probate. Now, what I've put on the screen is a very abbreviated but accurate depiction of how a probate works. And I'm going to leave this up here a little bit because, again, it's a process and there's time periods and so on. And it does take a little while in order for assets, especially real estate, and even more especially homestead real estate, to be sold. Now, most people, well, property is going to be owned a number of ways, okay? And this goes back to Real Estate 101, and I think every one of you probably knows this. Either you can hold real estate as an individual, whether you're married or not, as tenants in common, joint tenants. And actually, let me go back to the refresher. Tenants in common, 50% each of the whole. Joint tenants, and tenants in common, it doesn't necessarily mean 50%. It could be in other shares too. Joint tenants, where you have 100% jointly together as a whole, and that can be with or without rights of survivorship. Tenants by the entireties is a form of ownership for married persons, and it is very helpful, especially when it comes to creditor issues and so on. Life estate and enhanced life estate. Now, the enhanced life estate is really being used a lot more these days, and the difference between the two is that a life estate simply states that a person is allowing themselves to have the property and enjoyment of the property for their life, and upon their death, it goes to what we call remaindermen. Remaindermen are the people that are going to eventually have the fee title. However, during the life estate, they cannot commit waste on the property, they can't sell it, they can't encumber it, they can't do anything with the property that would otherwise create liens against the property. An enhanced life estate, on the other hand, you retain a lot of those rights. In fact, you retain just about all of them. So that upon death, it goes to your remaindermen. But if you change your mind and you say, you know what, I'd like to get a mortgage out of this property, or I want to build on this property, you have a right to do so. Trusts. Again, that's another way that you can own property. You can have it in the trust. Now, when it comes to the property, and when a person passes away, if the property was owned as joint tenants with right of survivorship, as tenants by the entireties, or if it's a life estate in which there's a remainder interest that went to a surviving person, then probate really should be unnecessary. However, this presumes that there's a surviving joint tenant or spouse who owns the interest in the property. Often there's not. And so when this happens, it has to go through probate. And if the probate was, if the property wasn't homestead, and homestead property is typically property that was used as a primary residence as their domicile, so they had the intent to remain there. And there's two different types of homestead I'm going to be talking about, and I'm going to get to that in a moment. But if the property was not homestead property, then in a probate proceeding, the personal representative, this is the person who's appointed by the court to oversee the probate estate, okay? It's often a family member or a friend or professional. Sometimes it's a bank. They have the authority in most circumstances to place the property for sale. But it will often require a court order to approve the sale. So don't be surprised if they say, well, I need a copy of the contract because I need to get the judge to sign the order. And in many cases, the judge is going to want an appraisal indicating that the estate is receiving fair market value for the property. Also, if there are other beneficiaries, if there are creditors that have a claim against this estate, they need to be notified of that sale and that there's a potential sale. So this becomes all of a sudden getting into a quasi-litigation mode. You need to make sure everyone's notified. And if anybody feels that the estate is not getting fair market value, they have a right to file an objection. So sometimes this has to be set for hearing. Getting hearing time with judges is not something where you can basically say, well, I'll schedule it for next week. It can be time consuming. How much time? Depends on the county, depends on the judge. Right now with COVID, things are moving a lot slower than they used to. I used to be able to get in to see a judge by, almost walking through the door years ago. You can't do that anymore. So just understand it may take time. If the property, on the other hand, was homestead, and the beneficiaries are heirs, in other words, they're entitled to claim the property as being homestead, then the personal representative needs to file something that we call a petition to determine homestead. Most courts are going to require that it not be filed until the claims period has run. When you file a probate, and let me see if I can go back. Okay, back to the probate process. You'll notice that there's a red line with arrows at both ends, and it says 90-day creditor claim period. When you file a probate, you have to publish a notice in the paper stating that there is a probate proceeding and that if you have a claim against this estate, you need to file a claim. If you don't do so, then you're barred. You don't get anything from the estate. However, they have a right to be notified, any potential creditors. Most judges, most courts are going to require that you not file your petition to determine homestead until after And if you'll notice at the end of that claims period, it says administer homestead property through the court. So what does this mean, for realtors? Well, generally it's going to take a few months before, depending upon where you are in the probate. If you basically received a contract a month after the probate began and letters were issued, well, there's a good chance that you're going to have to wait at least 2 or 3 months before you can actually sell the property. There is one get around on that, if I can put it that way. It's a workaround that we have, but not all judges necessarily go for it. And that would be something you could give me a call if you ever have that problem, and I'll tell you how that's done. But generally, they're not going to require it. And I did have this situation come up in the last 6 months, by the way, in which a realtor told me that she had a similar case and that they got the order almost immediately. And the seller's chosen title agent happened to also be an attorney. And so I gave him a call and spoke with them and asked them whether or not they would issue clear marketable title if the deadline had not passed. And he said, absolutely, they would not. And so he called the realtor and told the realtor accordingly. Now, since the realtor did not understand the significance of this problem, and she did not necessarily believe what I told her, she went ahead and placed a provision in the contract which actually penalized her own client if she did not close by a certain date. So she created a great deal of unnecessary stress, hundreds of unnecessary dollars in legal fees to meet a deadline, which was an unnecessary closing deadline. And that's where knowledge is power. And so if these issues come up, and I don't expect that you to be an attorney. I'm not a realtor, you're not an attorney, but you spot the issue and you call me or you call another attorney that handles these matters and say, okay, I have a situation, what do you suggest? And I'm going to give you a couple of suggestions in a little bit, by the way. Now, I provided in materials that I sent in on homestead, regarding homestead statutes and homestead property. But there's really 2 different types of homestead. One is the entitlement, basically up to the assessed value of $25,000 on the residence for property. In other words, basically the tax break that most realtors are familiar with, which is under Florida Statute 196. And there's also the homestead that is a bigger concern to me, which is under the Constitution, Article 10, Section 4, which exempts from claims of creditors the homestead. So I'm going to give you kind of like a basic understanding of the homestead, because Florida is very unique when it comes to homestead protection as stated in the Constitution. And when real property is in probate and it's homestead, there's a few issues of concern, because you can't freely devise homestead owned by one individual. For instance, if there's minor children or a living spouse. Although a properly drafted prenuptial agreement may waive the entitlement of a spouse. That's a different scenario. But keep in mind that property owned tenancy by the entireties will pass outside of probate to the spouse, even if there are minor children. It's where it's the individual that it becomes a bigger concern. If there's no will and the person owns property alone, the surviving spouse automatically gets what we call a life estate with in the property with a remainder interest to the decedent's children. And here's a kicker that can create a problem for a realtor. The spouse has a right to elect to receive a half interest in the property, not a life estate, but a half interest immediately, with a remaining interest to the decedent's children. And the problem comes in that the right to make this election of an interest is 6 months after death. And that could also delay a sale because the title company is not going to issue marketable title if you still have a spouse that has an election period to ownership in this property. Also, something else that sometimes people don't understand. These homestead laws and the homestead rules even apply if the property is held in a trust. So putting it into a trust doesn't negate the right to the homestead. I'm going to give you also a real life scenario here of a problem that comes up, and this is one that came up fairly recently. So it was kind of, I guess, timely for our discussion. I had a potential client come to see me. He wants to get a piece of property that was valued at about $139,000 that was allegedly owned by his father. His father had 8 children, and he passed away about 15 years ago. Prior to his father passing, he deeded the property into his and his daughter's names. Sometime later, he deeded the property back into his name alone. Both deeds were done by quitclaim deed, of course, and they used the forms that I don't know, Easy Forms or Office Depot, quitclaim forms. After he passed, a number of his grandchildren started living in the property. Often they didn't pay the taxes, and it would go in and out of tax lien status. The property now has years of back taxes, and some of the family came to the potential client asking him to pay off the taxes. He's agreeing to do so as long as he can have the property placed in probate so that the property can eventually be sold and held for the benefit of the family. And to make things a little more complicated, 2 of the decedent, the father, the original owner, sons, passed away after their father, leaving behind 5 known children of their own. And lastly, not all the family members agree on how this matter should be handled. So this was pretty much a bit of a mess. And as attorneys, we often refer to these as law school questions. Now, for those of you that haven't heard that phrase before, law school questions are those that are intended to not simply be difficult, but often deceptive. The above example has multiple issues of concern that an attorney would have to address, including whether or not the deeds were valid. Determining how many children actually exist becomes a major headache because we can't just take someone's word for it. You really have to investigate, especially when there's the potential that there's a lot of half siblings also. And since the property was not probated immediately, there is an issue as to who owns or has a right to the interest of the 2 children who passed after the father. Now, the children of those beneficiaries, by law, will have a potential interest in this piece of property, in addition to the original children of the decedent. As you can see, the pieces of the real estate pie are getting smaller and smaller. the cost and difficulty of a probate plus 2 additional potential probates for that 1/4 interest that our potential client might have keeps increasing. So how much of this estate will be left after legal fees? Was this potential client going to invest a lot of money for a minor interest? These are the type of cases where my wife comes back again and says, I wouldn't want your job for anything. And, but that's the way it is. Now, in the diagram above, which does have one small error, and I don't know if anyone caught it, but at the very top, the delta, which is the decedent, transferred the property to him and his daughter. So there should have been a delta and a letter D. But otherwise, if you take a look at it, this is what happened. You had the decedent, 5 children, 2 of them died, leaving behind 5 more children at least. And their share interest I've put in there just so you can see, what their potential interest. Each one of these people would have to agree to the sale of the property if you wish to sell it at a later date. So, it becomes quite complex. It's important for the realtor to understand that prior to executing the contract for sale, knowing who actually owns the property. Don't take the word for the individual. Hopefully you don't, okay? Also, just because there is a probate estate open doesn't necessarily mean that they have the authority to execute the contract for sale and purchase. So here's some advice. If you're dealing with the personal representative of the estate, I would suggest that you may want to speak with their attorney. Ask if the personal representative currently has the authority to sell the property. Is the property homestead? And if so, when a petition to determine homestead will be filed, and when an order is likely to be signed, because that's going to be your time frame in order to get the sale done. Will a court order approving the sale be necessary? And how long would they anticipate for that hearing? You want to have a ballpark of the time frames. If you represent the buyer, time considerations become an issue. If an issue does arise, can your buyers afford to wait on a closing that may be delayed because of probate issues? If so, for how long? Set a time limit. Possibly ask for a buyer's credit for additional time to close. Before you have a seller, I'm not worried about the buyer here, but the seller sign the contract for purchase and sale, you may want to include a contingency provision for the probate. I've put a sample provision that you can use or adjust or whatever is necessary that basically shows that, yes, there is a probate going on, that the contract is contingent on the personal representative obtaining that authority. You don't want to basically get into litigation because you weren't, the seller wasn't able to get the job done if there is a problem down the road. So you make the contract contingent upon their getting the necessary orders from the court. And the best efforts provision is always kind of nice, and put in how long the closing can be delayed if necessary. And, if it can't get done, everyone goes their separate ways. There's so much to understand about this subject. And again, I don't expect you to, be the lawyer here. That's not your job. Just issue spot. If you're not sure, contact the estate attorney, or if there's no estate, because that comes up often too, because a lot of my cases are referred by title companies that run into this problem. They say, hey, this property needs to go through homestead. And I've been able to get it done pretty quick for most of them. So if these issues do come up, either give me a call, give someone else a call. And, Ben knows me. If you have an issue and you just want to run it by me, give me a call. I'm with Ben Laube Homes. I have a little issue here. Can we just chat about it? Do I have a problem? Can I, this be resolved? And if you have a person that needs the assistance with a probate, certainly I'm there to help too. I tried to keep it within your time frame. It's for attorneys, generally, this is a subject that you can spend almost half a day on if you really want to get into it. So I appreciate your patience. I appreciate your having me chat. If you have any questions, I'm happy to take questions. If you want to contact me at another point, I'm here. Use me as a resource. So again, thank you again for your time.
Thank you so much. I absolutely appreciate you taking the time to come in and speak with us about this. It is something that keeps coming up for us regularly. So it's good to hear from an expert in the field, because these are questions that we wouldn't be able to answer necessarily on our own, nor should we be, to be completely honest. So I'm glad to know that we have you as a resource. Anybody on the call have any questions?
I don't have a question, but this was very insightful. Thank you so much. I really appreciate it.
You're very welcome.
Thank you very much. It was great.
Perfect. For those of you on the team, if you ever are in need of advice in this subject matter, you can find Mr. Heller on Follow Up Boss with his contact information. So he is there.
Again, thank you very much for your time, and any questions, I'm definitely here, and I'm happy to help. That's I can't say anything more than that. Okay?
Absolutely appreciate it. Thank you so much.
You all have a very good day, and enjoy the rest of your meeting.
Thank you so much.
Bye-bye now.
Thank you.
Bye.
Bye.
All right, so just a couple of things that I want to cover before I let you all get on your day, on about your day, I should say. First, any big wins or lessons learned from yesterday that we want to talk about, or any deal specific questions that you're facing?
Two things. One question. First, I have my listing go live, so that's exciting.
Yes.
Showings already scheduled for today. The sellers are so nice and they're very excited, so it's great. But I do have my buyers that have an inspection. They went and scheduled the inspection on their own. They did not want to go with one of our preferred inspectors, which I told them, of course, is fine. So we have that tomorrow morning at 9 a.m. Just any tips anyone can give me for going through an inspection. This is going to be my first one. Yeah, what should I expect? And yeah, anything that y'all have learned that is helpful to be prepared for.
In my experience, you should expect to stand around and be bored for a few hours.
Okay.
And then at the end of the inspection, assuming that the inspector they've chosen reviews the inspection with you at the end. Sometimes they do, sometimes they don't. Erica, it's true. Sometimes they do, sometimes they don't. I don't know which inspector they've chosen. So they may go over it with you at the end, they may not. If they don't, then you can look forward to the inspection report showing up in your email inbox after the fact. And then you would need to go over that, find out if anything there concerns you. Your buyers will do the same. And then if there's any negotiation necessary, then that would have to take place after the inspection report is received. Also be prepared to, if you end up having to negotiate a repair or a credit or something of that nature, be prepared to share the inspection report as evidence of what you're asking for. Otherwise, if you just go to somebody and say, hey, yeah, we need a credit for $2,000 for whatever's broken, you have no proof. You're just asking them for $2,000. So be prepared to provide evidence of what you're asking for.
Hope it comes back good. The previous buyers backed out due to financial problems. So their inspection came back almost clean. The only thing was the cloth wires that they had, because it's an older home built in
Mhm.
68. So those were already replaced on Monday, according
Cool.
to the listing agent. So hopefully it will be clean.
Okay, cool.
Fingers crossed. But thank you, Lee. Appreciate it. Yeah, I figured it's just gonna be me standing around, and also the buyers wanted to be there. I mean, do you recommend them being there the whole time, or just have them come in towards the end?
It's their preference.
Okay.
If they want to be there to kind of follow the inspector around and, you know, hear things or see things real time,
Mhm.
then great. But I would absolutely at least recommend that they be there for the end, the last half hour or so, so that the inspector can share findings with them at that point.
Okay.
Anybody else have any thoughts or suggestions on that? No.
It's not a huge house, so you time frame wise, you're like 2 to 3 hours.
I would say that, yeah.
Okay.
It depends though. I literally, my last listing, it was a 3-bedroom, 2-bathroom, 1,200 square foot unit. And that
Mhm.
guy was literally in and out in 40 minutes.
Oh. Okay.
It wasn't my buyer, it was my seller. So I said, if they ordered a, crappy inspection company, so be it. I was like, the minimum amount of time that any of the inspections for my buyers have taken has been at least 2 hours. So, but if it's your listing, it's your buyers,
My buyers,
Yeah,
yeah.
whoever they end up going with, I mean, it could be anywhere from 40 minutes to 2 to 3 hours. Yeah.
Okay. So I'm an open house at 2, so that's 30 minutes away. So I'm like, I hope it doesn't go on forever. They said that it's an older guy that's been doing this for a long time, so maybe he will be quick because he has been doing it for 30 plus years. So
Yeah.
Well, if you
Fingers
get
crossed.
in a time crunch and stuff, Gavin, let me know and I'll do what I can to come help you out.
Oh my gosh, thank you. Thank you so much, Matthew. Yeah, because I literally just need help locking it up. So I know I'm not gonna leave them there. But yeah, I'll keep track of the time and I'll text you. Thank
All
you
right, sounds good.
so much.
Anything else? Okay, cool. Really quickly, because I totally forgot to do it yesterday, I wanted to provide you with an update on our progress toward our monthly goal. I totally forgot it yesterday, and I'm so sorry. So really quickly, I'll show you how we are progressing. We still have a few days left in the month, so we might get it. And if not, certainly did a hell of a job trying. So here's where we are right now. Our goal for the month was to have 25 contracts signed. As of yesterday, we have 19. We have a couple of listings that are live right now, Saxon's and Gavin's. We also have Marara's listing is going live today. So there's a potential for 3 new contracts right there. And then I know some of you are working with buyers as well. So yeah, if we can get just 6 more deals under contract, we will have met that goal of 25 deals under contract within the month of October. On the sales volume side, we're currently at just under 5.3 million. Our goal was 7.5. So yeah, we're right there, and we've only got just a little bit of space left to fill up. So let's see what we can do to really make these last few days of the month work for us. Questions on that?
We would have been at 20. I got an executed contract back last night, but the buyer's going to back out because she's a nightmare.
That's okay. Maybe we'll get her under contract on something different before the end of the month.
Perhaps.
No, fire her. You need to fire her.
No, I know.
Is that Melissa still?
Yes, this is Melissa. I kid you not.
Oh my gosh. I need to do showings with you one day.
Okay. Yeah.
So you can talk some
To
sense
help
into
you
her?
out because no, it's just like she's just too much. I mean, at this point, like she's just wasting his time, and
What
it's
is
just
her
a
issue?
lot.
Everything.
Everything.
She's
No, but I
literally,
mean,
she's been a nightmare since day one.
But like how?
Her listing, we're under contract, and she's been so combative about every little thing that the buyer wants regarding Airbnb reservations We're having to set up an escrow account. I'm having to put my own money in. Like, it's been so bad. It's been so bad. And then her buying, she had me schedule a bunch of stuff in DeLand and then called me that morning and was like, never mind, I want to go look in Ocala. Sent me 13 addresses for me to schedule last minute. I was literally driving, holding my iPad and my phone. I nearly killed myself trying to accommodate this woman. We finally find a house. I spent the last 3 days going back with the HOA because there's one rule that isn't, she's got 4 dogs. They only allow 3. So I've gone back and forth with the HOA. They're going to make an exception. They wouldn't do it in writing. I got them to put it in writing. Finally drafted up the offer again last night and they accepted it. And then she called me 10 minutes after I got the executed contract back and said she can't do it. So it's been
going through all of that.
Yeah, she's just been, and so she's going to look in Palm Beach now. So, and I'm not going to help her. It's just,
She just remind me of Anna too much. And I feel like I think she's going to continue doing it. That's my concern because that was Anna for the longest time and they're like difficult and never satisfied. They'll get into contract a few times, they'll do inspection and then after inspection, no, it has this little thing and I don't want it anymore. She's just that kind of person.
Where'd she come from, Nick?
Hell.
Facebook. I had posted about my other listing and she called me within like half an hour and she was like, I've got a unit in Toscana that I need to sell. I'm getting all this attention. I don't want to deal with it. I need to hire you. I like how you laid things out. Will you list my house tomorrow? I was like, oh my God, sure. So I did. But and then like, and I need to buy, but she has RVs and dogs and oh my gosh, that she needs to park on the property. It's just better there.
OMG. All right. Well, good luck with that. Hopefully it works out.
Thanks.
All right. We are way over and I apologize. I will let you all go so that you can get on with your day. If you need anything at all, please reach out. I'll be around most of the day. I have an appointment this morning later on, but other than that, I should be around. And yeah, talk to you later on.